Most people imagine a personal injury lawsuit works like a television drama. You get hurt, you hire a lawyer, and you sue the at-fault driver in a packed courtroom for millions of dollars. In the days following a crash, that instinct is understandable. You're in pain, you're missing work, and the medical bills are stacking up. However, injury victims rarely recover money directly from an individual driver's personal bank account. The true target of a personal injury claim is the at-fault driver's auto insurance policy. Success depends on a strategic financial extraction from that specific contract. This process is governed by policy limits, a legally binding mathematical ceiling on the total money available for recovery. Even with catastrophic injuries and medical bills in the hundreds of thousands, recovery stops at the insurance policy's printed limit. While you're trying to reach that maximum to cover your expenses, the insurance company is working to settle the claim for a tiny fraction of what is available. This creates a war of attrition. You need the recovery pushed to the full coverage cap, while the insurer uses their resources to keep it as low as possible. Because of these caps, the first phase of a claim is a coverage investigation. Your legal team must map out every potential source of funds to build your recovery. In Florida, this means hunting for 3 specific sources: your own personal injury protection, or PIP, the at-fault driver's bodily injury liability policy, and your own uninsured motorist coverage. The process hits a wall when the at-fault driver has zero insurance, and the victim has opted out of uninsured motorist coverage on their own policy. If there is no insurance coverage available across any of these branches, no financial recovery is possible. A law firm cannot create funds where no policy exists. When coverage is located, Giddings Law Group builds an evidentiary case to demand the maximum policy limit. Sometimes, the insurance company sees the overwhelming medical evidence and agrees to pay that entire limit immediately, before a lawsuit is even filed. This creates the trial paradox. If the insurer agrees to pay 100% of their legal obligation during the pre-suit phase, there is no further legal mechanism to sue them. Victims who are rightfully angry at the driver may feel this is a missed opportunity for a day in court. But this result is the primary objective. Securing the full mathematical recovery without filing a lawsuit avoids the years of delay and the unpredictable risks inherent in a jury trial. Navigating these thresholds and legal deadlines without an attorney often leads to avoidable mistakes. Insurance adjusters frequently offer quick, lowball settlement checks within days of the crash. They want you to sign away your rights before you understand the long-term cost of your medical care. They also monitor your digital footprint. A single social media post can be used to argue your injuries aren't as severe as your medical records suggest. Data shows that victims who fight insurance companies alone are statistically less likely to reach the true ceiling of their available compensation. While no firm can create coverage out of thin air, a dedicated team knows how to extract the maximum amount from the policies that do exist. Giddings Law Group operates on a contingency fee basis. You pay nothing up front, and the firm only collects a fee if they successfully win a settlement. To protect your recovery before deadlines expire, contact Giddings Law Group today for a free case evaluation. The personal injury system is a maze of strict limits and deadlines. Having an expert guide is the most effective way to ensure you recover every dollar you are legally owed.